Hey there, I'm Paul Rabalais, and in this video, I'm going to take a unique approach to helping someone determine whether they should use a will or a revocable living trust to leave their estate to their heirs. What's unique about this approach is that I'm going to show you a tool that me and a technology team created to help people decide what is the best estate planning fit for their unique situation. So I co-founded an estate planning technology company, and today I'm going to show you our website that helps you determine whether you should leave your estate the traditional way that most people are familiar with, through a last will and testament, or whether you are better off leaving your estate to your heirs or beneficiaries through a revocable living trust. And my goal is not simply to help you come to the conclusion of which is most appropriate, but to also explain the questions that you must answer in order to make that determination of will or living trust. So let's jump in. The first thing you will see when you go to the myadvocate.com website is an invitation to take a free assessment. So let's click that and go to the assessment. Now, once you get to the assessment page, you will be asked a series of questions. There are three reasons these questions are there. First, they help you determine whether a will or living trust is a better fit for you. Second, gives you an introduction to the subject matter that gets addressed when you do create your estate plan. And three, because estate planning can be complicated, your answers to these simple assessment questions tell us what questions both need to be asked and what questions do not need to be asked if you were to proceed with customizing your estate plan for yourself and your family. So I'm going to take a moment to both show you the assessment questions and give you the why these questions are being asked. Now, let's say, for example, that someone named Phil is taking the assessment. The first question asks whether you have a spouse or life partner. Note that with every question, there is a question mark icon here that can give you additional context to the question if you want it or need it. The reason we ask if you have a spouse or life partner, which I'll simply refer to as spouse in the future, is that unmarried people will typically create their estate plan alone, while married couples tend to create their estate plan together. But because some married people want to create an estate plan without their spouse, we asked Phil whether he wants to complete this with his spouse, and he indicates yes. The next question we asked Phil is whether he or his wife, who is Claire, have children. The reason we ask Phil whether he has children is that people who have children often want to leave their estate to their children. And since Phil answered yes to this question, our software now knows to give Phil and Claire those options that one would want to have who wants to leave their estate to their children. Next, we asked Phil whether he wants to name guardians for minor children. Every parent with one or more minor children should designate in their estate planning documents who they would want that backup parent to be if something happens to the parent or parents of the minor child prior to the child reaching the age of majority. But let's say Phil has no minor children, they're all over the age of 18, so he leaves that selection at no, and the software knows not to bother asking Phil any more questions about legal guardian for minors designations. Next, Phil gets asked whether he wants to select who will settle his estate when he passes away. This lets Phil know he needs to start thinking about who will be the executor of his will, or if he winds up with a revocable living trust, who will be the successor trustee of his revocable living trust. Another reason we ask about this, as the help describes, is that if Phil ignores estate planning, a judge will select someone when Phil dies to oversee the settlement of his estate in accordance with the state law where Phil lived when he died. Okay, so next, Phil gets asked whether he wants to create powers of attorney. While the answer to this question does not directly address whether a will or a trust is the best fit for Phil, it does let Phil know, hey, Phil, no estate plan is complete without addressing these incapacity issues. So we're going to give you a heads up that you should address these issues. Next, Phil and Claire get asked whether they want their children to inherit equally. When people do want their children to inherit equally, you'll often see the legal documents reflect that the parent's estate is left to the, quote, descendants per stirpes. This not only leaves the estate to the children equally, but it also means that if a child predeceases the parent, then the deceased child's share will pass to the deceased child's children. Next is another one of those heads up questions. When many people think of providing for their spouse, they think that everyone just leaves ownership of what they have to their spouse. But as the help indicates here, there is more than one way to leave things to your spouse, particularly if you are concerned about where your estate goes when your surviving spouse later passes away. Occasionally, grandparents want to leave a certain sum of money to each of their grandchildren, whether that's intended for college education or just simply to give the grandchildren a head start on life. Next, Phil can indicate whether he wants to leave any of his specific assets to certain people. Not everyone carves out particular assets from their estate for certain people. In fact, many people choose to simply leave their entire estate to their heirs without mentioning specific assets. So if Phil answers yes to this question, that will tell our software that we created whether to ask Phil further questions about leaving particular assets to particular people. The next question addresses those critical estate planning concerns when one or both spouses have children from a prior marriage or relationship. Phil has a child or had a child before he married Claire, so he selects yes. Regarding these further protections, we asked Phil whether he wants to prevent estate disputes when he passes away. You may be thinking, well, who wouldn't? But this question conditions Phil to address those future questions he will be asked about whether to include a no contest clause in his estate planning documents. The next question is related to an earlier question about providing for a spouse. Once married people look into this, they often feel strongly that they want to provide for their spouse, but they also want to protect the future inheritance of the children or other beneficiaries by leaving assets to a trust for the spouse instead of leaving assets directly to the spouse. Next, we asked Phil whether he wants to protect the inheritance of beneficiaries who may need their inheritance managed in a trust after Phil dies. Note that by looking at the check marks on the right-hand side of the screen, even if Phil answers yes to this question, it does not conclusively mean Phil must get a revocable living trust to accomplish this. He could also create testamentary trusts within his custom will to provide that protection for one or more of his beneficiaries. An estate planning area that is becoming increasingly popular is setting up the inheritance for the children or beneficiaries so that the inheritance is protected from the child or beneficiary's divorces. Phil got hit hard financially years ago when he got divorced from his first wife, so he definitely selects yes here. These days, there are unique considerations from an estate planning standpoint when someone has cryptocurrency or NFT, so we asked Phil about that. The questions about charities and pets allow us to know whether we would ask Phil questions about customizing his estate plan, such as establishing a pet trust for their pets that they may have when they pass away. Here, Phil just leaves it no, so that eliminates future questions about charities and pets. An important consideration for those with special needs, children or beneficiaries, is to set up their inheritance in order to protect certain government benefits those beneficiaries may be receiving at the time of the inheritance. The next question regarding allowing a business to continue without disruption does have will or trust consequences. You see, if you own a business and you want to designate someone to be able to continue operations of the business after you pass away without difficulty, it will be easier if you transfer your business interest to your living trust during your lifetime, so that immediately when you pass away, your successor trustee can continue to operate your business without having to wait on lawyers and judges to get involved. So you'll see this check mark only under living trust on the right-hand side when someone says they own a business and they want to make it easy for business operations to continue. Next is a question which is designed to make people realize that if they don't create an estate plan, the government will say who gets your assets when you pass away. So Phil, just like about everyone, selects yes, because pretty much everyone wants to have that say-so regarding who benefits from their estate when they pass away. The next question asks Phil directly whether he wants to create a living trust. Some people come to our website already knowing what they want. So if Phil comes to our website already having educated himself enough to know that he wants a living trust, he would select yes. But if Phil wasn't sure what a living trust was, he could hover over the question mark and then find out a little bit more and then make that decision of whether or not he and Claire would want to have a living trust. When someone uses a living will, or when someone uses a will to leave their estate to their heirs when they die, that will gets recorded into the public records of the courthouse. Some people want to have more privacy regarding their estate, and thus a living trust can provide more privacy to you and your loved ones than a will would provide. So you'll see the check mark under living trust on the right-hand side on this privacy question. Now, once Phil answers all of these assessment questions, it was maybe 20 questions or so, then Phil simply selects view the results. And that will take them to the results page where they will see that their answers to their assessment indicate that the living trust plan is the best fit for their situation and their estate planning objectives. It helps them avoid probate, continue business operations, and enhances their privacy. Now, Phil and Claire could choose, if they wanted to, the custom will plan instead of the living trust plan, but with what they want to accomplish, the living trust is the better fit. So if they wanted to, they could stop right here and just have a little bit better understanding of whether they should have a will or a trust as the way to leave their estate to their beneficiaries. And by going through the assessment questions, they'll have a little bit better understanding of which questions and what subjects they'll need to address when they do get involved in answering the specific questions that are involved in creating a estate plan. But let's say for kicks, they want to try it out and just take a look and see what's next. Then they would create an account with their name and their email, and then they would be asked a series of questions by our software. This is one of many, many questions that they would be asked, but this is the question that asks Phil, how do you want Claire to receive the remainder of your estate? So there's different options there, and there's 3 answers that he can answer. And maybe Phil reads the question and the answers and says, you know what? I think I know what I want, but I'm not real sure. Then he could go to the text help, which is here on the left, and read a little bit more and get a little more context about that question. If he wanted more, he could click on the arrow here and just watch a short video about that specific question and the answers that are provided. So the software is designed to not only ask you questions and get answers, but also provide you with text and video support. You'll be asked questions, many, many questions, not only how you want to leave things to your spouse, how you want to leave things to your children, who will be your executor, your trustee. Do you want to leave things to people outright or in a trust for them? If you leave things in a trust for them, when will they get it? Will it be at a certain age or within so many years after your death? Or would you want to appoint a trustee to have the discretion to determine when your children or beneficiaries get it? So many, many questions. Who would you want to have financial power of attorney? Who should the backup be? Same with healthcare decisions. Lots and lots of questions there. And then every time you get through a section, and there's about 6 or 7 sections of questions, you'll be presented with a diagram of those questions that you were just asked. And it makes it easier with this diagram view to understand what's going on here. So here's where Phil said that when Phil passes away, his assets will be in the Phil Dunphy Trust, and they'll be in trust with Claire, his wife, receiving the income from those trust assets for the rest of her lifetime. Claire will be the trustee of that trust after Phil dies, and if Claire ever gets to a point where she can't be the trustee, or quite frankly, when Claire dies, then Alexandra will be the trustee. And then some of the key trust provisions of that trust is if the trustee determines that Claire needs distributions of principal for her health, education, maintenance, and support, trustee would be authorized to make distributions to Claire for the rest of her lifetime for that. And then when Claire later dies, any remaining assets in the Phil Dunphy Trust would pass along to the remainder beneficiaries, which are just described from a different set of questions and answers and will be demonstrated in a different diagram. So Phil and Claire would go along one step at a time, answering questions, using the help if necessary after each section, taking a look at the diagrams. And then after that, then if they want to make all of this official, they would take care of the payment provisions on the website, and then they would be sent to an area where they could review and print and sign all of the legal documents, their wills, their trust, their powers of attorney, their healthcare documents. What you see here is just page 1 of their trust, and it's a several-page instrument along with all of the signing instructions, and all of the documents that are produced on this website are designed to be in compliance with all 50 states. We've done all the research on what all the 50 states require, and here it says that Claire and Phil live in California, so obviously this all the signature pages on their trust are in compliance with all of the California signing requirements. So they would simply print that off, sign it, get it notarized where appropriate in order to make it official. So what we got here is really anybody in America can go on our website, myadvocate.com, can answer those 20 or so simple assessment questions, see what our software considers to be the best fit for your situation, and then go in and dig deeper on those matters that the assessment uncovered are most important to you, answer all those questions, and then when appropriate, or when you're ready, go ahead and take care of the payment options, and then all the documents are auto generated, and once they're all executed, then we're all good there and everything's official. Okay, hope that helps. Y'all have a great day. Take care.